For the past year, immigration enforcement has moved far beyond routine policy execution and into something much more disruptive, something that is now colliding head-on with the foundations of the justice system itself. What began as aggressive enforcement has evolved into a pattern of legal conflict so intense that federal courts across the United States are no longer speaking in cautious, measured tones. Instead, judges are issuing unusually sharp warnings, escalating enforcement actions, and openly questioning whether basic legal boundaries are being respected at all. At the center of this growing storm is a simple but powerful principle: court orders must be followed. Without that, the entire legal system begins to fracture. And yet, in case after case, judges are finding that orders issued from the bench are not being treated as binding commands, but as obstacles to be delayed, ignored, or worked around. This is not a technical disagreement over procedure. It is a direct challenge to judicial authority, and courts are responding accordingly. Recent developments in Minnesota have become one of the clearest examples of this breakdown. Federal judges reviewing immigration cases have documented widespread non-compliance with court orders, particularly in situations involving unlawful detention and the failure to provide due process. In dozens upon dozens of cases, individuals who were entitled to release or hearings remained detained, sometimes transferred across state lines, sometimes left without explanation, and often without the basic legal protections guaranteed to them. The scale of the issue is what has truly alarmed the judiciary. In a single month, courts identified nearly 100 violations of court orders across dozens of separate cases, with judges warning that the real number was likely even higher. Subsequent reviews expanded that number significantly, revealing over 200 violations across more than 100 cases. These are not isolated mistakes. They form a pattern, one that judges from across the ideological spectrum have described as unprecedented. This is why the language coming from the bench has become so forceful. Courts have stated openly that they are not aware of another moment in U.S. history where they have had to repeatedly threaten contempt just to secure compliance from the government itself. That statement alone signals how extraordinary the situation has become. Contempt of court is not a routine tool. It is a last resort, used only when all other mechanisms have failed. And yet, judges are increasingly turning to it. To understand why, consider what these cases actually involve. Many of them center on individuals who were detained without proper legal justification. Courts reviewed their cases and ordered specific remedies: release the detainee, provide a bond hearing, return personal property, or halt a transfer. These are not vague suggestions. They are precise, enforceable directives. But instead of being carried out promptly, they were delayed or disregarded. In some cases, individuals were ordered released but remained in custody for days or weeks. In others, they were transferred to distant states despite explicit court instructions not to move them. Some were released, but never had their identification documents returned. Documents that are essential for working, traveling, or even proving who they are. Without those documents, a person is effectively locked out of normal life, even after being freed. Judges have made it clear that these failures are not harmless administrative oversights. They have real consequences for real people. When someone is detained unlawfully, every additional day in custody is a violation of their rights. When their property is not returned, it prevents them from rebuilding their lives. When court orders are ignored, it signals that the system designed to protect individuals is no longer functioning as intended. This is where the role of immigration enforcement agencies has come under intense scrutiny. Courts are not merely criticizing isolated errors, they are confronting what they describe as systemic misconduct. The repeated nature of the violations has led judges to conclude that this is not simply a matter of overwhelmed staff or logistical challenges. Instead, it reflects deeper structural problems in how enforcement actions are being carried out. In hearings and written opinions, judges have rejected explanations that rely on high workload or limited resources. Those factors, they argue, do not excuse disobedience of court orders. If anything, they highlight a failure to plan for the legal consequences of large-scale enforcement operations. When thousands of individuals are detained, it is entirely predictable that courts will be flooded with legal challenges. failing to prepare for that reality does not justify ignoring the outcomes. What makes this situation even more striking is the bipartisan nature of the judicial response. The judges issuing these rulings were appointed by presidents from both major political parties. Some were appointed by conservative administrations, others by liberal ones. Yet they are reaching similar conclusions, that the conduct they are seeing is incompatible with the rule of law. This undermines the idea that the criticism is politically motivated. Instead, it suggests a deeper institutional concern, one that transcends partisan divides. When judges who typically differ on legal philosophy begin speaking in the same urgent tone, it indicates that something fundamental is at stake. Another critical factor driving this crisis is a shift in how courts are allowed to issue rulings. Recent legal changes have limited the ability of judges to block government actions on a nationwide basis. Instead of issuing a single ruling that applies across the country, courts are often restricted to granting relief only to the individuals involved in a specific case. At first glance, this might seem like a technical adjustment, but in practice, it has had profound consequences. It means that even when a court determines that a policy or action is unlawful, that ruling does not automatically stop the same conduct elsewhere. Other individuals must file their own cases, go through the same legal process, and obtain their own rulings. The result is a flood of repetitive litigation. The same legal question is asked again and again, with courts issuing similar decisions each time. This not only overwhelms the judicial system, but also allows problematic practices to continue in the gaps between cases. It creates a situation where enforcement actions can persist despite being repeatedly ruled unlawful. Judges are acutely aware of this dynamic, and it is contributing to their frustration. They are effectively being asked to solve the same problem over and over again, without the tools to address it comprehensively. This repetitive cycle erodes efficiency, consistency, and ultimately confidence in the system. At the same time, the human impact continues to grow. Individuals caught up in these enforcement actions often face uncertainty, fear, and disruption. Families are separated, workers lose their jobs, children are affected, and when legal remedies are delayed or ignored, those harms are prolonged. Courts have emphasized that the Constitution does not allow for shortcuts in the name of efficiency. Due process is not optional. It is a fundamental requirement, especially when the government is exercising its power to detain individuals. When that process is bypassed, it is not just a legal violation, it is a constitutional one. This is why some judges have begun to escalate their responses. Civil contempt, which is designed to compel compliance, is being used more frequently. And in more serious cases, judges are openly considering criminal contempt, which is punitive and intended to uphold the authority of the court itself. The distinction is important. Civil contempt says, follow the order and the penalty goes away. Criminal contempt says, you have already crossed a line and there will be consequences regardless. When courts begin to consider the latter, it signals that they believe the issue has moved beyond simple noncompliance into something more deliberate. This escalation reflects a broader concern that if court orders can be ignored without consequence, the entire legal system loses its meaning. Laws are only as strong as their enforcement, and enforcement depends on the willingness of all parties, especially the government, to abide by judicial decisions. Meanwhile, public understanding of these events is often shaped by how they are reported. Different sources may emphasize different aspects of the story, leading to vastly different perceptions. Some focus on the enforcement goals, others on the legal violations, and still others on the political implications. Without careful attention, it becomes difficult to see the full picture. What remains clear, however, is that the tension between enforcement actions and judicial oversight is reaching a breaking point. Courts are asserting their authority more forcefully than they have in years, if not decades. They are documenting violations, holding hearings, issuing sanctions, and making it clear that continued defiance will not be tolerated. In this context, the role of immigration enforcement agencies is being redefined in the eyes of the judiciary. No longer seen merely as executors of policy, they are now being evaluated as actors within a legal system that demands accountability. When that accountability is absent, the response from the courts is swift and increasingly severe. At its core, this situation is about more than immigration policy. It is about whether the rule of law can withstand sustained pressure from within the system itself. It is about whether court orders remain binding or become negotiable. And it is about whether the balance of power between branches of government can be maintained in the face of escalating conflict. The judiciary has made its position clear. It will continue to enforce the law, to protect constitutional rights, and to use every tool at its disposal to ensure compliance. Whether that includes fines, sanctions, or even the possibility of imprisonment, the message is the same. The authority of the courts is not optional. As this story continues to unfold, one thing is certain. The outcome will not just affect those directly involved, it will shape the future of how laws are enforced, how rights are protected, and how power is checked in one of the most critical systems in any democracy.